Hey folks, welcome to the Four Boxes Diner. We have a very special treat for you today. We are interviewing David Thompson of the prominent law firm Cooper & Kirk, the man and his firm that started the case you may have heard of, NYSRPA versus Bruen. David Thompson, welcome to the Four Boxes Diner again.
Mark, it's great to be with you. Thanks for having me today.
Well, for those of you who don't know David Thompson, I'm sure you're familiar with his work because he's one of the most prolific Second Amendment litigators in America. As a managing partner of Cooper & Kirk, David Thompson is a graduate of Harvard undergraduate. He is a graduate of the Harvard Law School. He has argued before the Supreme Court on multiple occasions. And David Thompson, I don't know, we can go on and on and on about your bio, but it would take up the whole interview. So I'm going to stop right there and ask a simple question. The first time somebody argues before the United States Supreme Court, what advice do you give them or what inside tip do you give them before they step into that intimidating courtroom and talk to Justice Roberts and the rest of the Supreme Court?
Well, Mark, that's a great question, and we could have a whole video about that. I think the one thing I'd say is there is an emphasis on collegiality. So even when the anti-gunners or the liberals are making some totally intellectually bankrupt argument, it's important to call them my friend. So it's my friend has suggested this stupid argument rather than the anti-gunners are, have made another egregious mistake.
Well, that's great. That's great to hear, David. And I think that's good advice. It is very collegial there, and they take their jobs very seriously as intellectuals, and they try to get it right as best they can at the Supreme Court. It's a hard job, and that's not a job I would want to be a Supreme Court justice. Too hard for me.
Well, we'd like to see you on that court, but that's another question. Go ahead.
Well, if I became a judge, I couldn't do the YouTube channel, right?
That's true. That's true.
So, David, let me just start off here. So here we are. We're sitting about 8 months out of the decision in NYSRPA versus Bruen, which in many respects was not a dramatic change in the law. It really just sort of told the lower courts that the Heller decision and the methodology articulated by Heller is the law of the land, and to stop messing around with these interest balancing tests that empower the judges to balance away our fundamental rights. But with that said, obviously, NYSRPA versus Bruen was a case that really sort of set down some guardrails for the lower courts. And in light of that, David, why don't you just tell us briefly, in your view, what exactly is the Bruen methodology when people use that phrase?
Well, you're right, Mark, 100%. The Bruen simply elaborated upon the Heller text and history approach. Anyone who was intellectually honest who read Heller should have known that's what it meant, because that's what Justice Scalia did. But as you adverted to, there were a lot of lower court judges who took an intellectually dishonest approach to Heller, and now they've been admonished. And now they've been told by the United States Supreme Court very clearly that when they said text and history, that's what they meant. And it's really a simple process. Number one, you look at the text to see, does the activity that's governed by the law at issue fall within the text? And if so, then the burden shifts to the government to find a historical analog that is relevant, both in terms of the how and the why, how it was implemented, why it was adopted. And if they can do that, and it was widespread, well, then there's a discussion. But if they can't do that, then the ban must fall.
So let's just start with step one for a second, the plain text. Tell us about what exactly does the phrase plain text really mean, and what is in it and what perhaps is not within the scope of that phrase?
Well, it's, as you suggest, it's looking at the dictionary definitions from 1791 when when the Second Amendment was adopted, and the two key dictionaries that the court tends to look at. There are a multiplicity that they look at, but the two most important are Dr. Samuel Johnson's original Dictionary of the English Language, and then Noah Webster's, which comes in 1828 and is an American English version. And those are the two leading dictionaries you look at. And if you look at those dictionary definitions and what the government is trying to ban falls within that, then the burden shifts and we start talking about history.
Now, David, the phrase, the right of the people to keep and bear arms shall not be infringed. Have those words been defined and discussed by the Supreme Court already in their opinions?
Absolutely. So the United States Supreme Court has already held what the plain text means. With respect to the people, it means all Americans. All Americans are covered by the term the people. Keep means possess. Bear means to carry. And arm means what Dr. Johnson defined it to mean, any bearable weapon of offense or defense. any weapon of offense or defense that's bearable is an arm. So that's all of those key words have been defined. The left tries to make some mischief with, well, infringe, that's different than abridge. The United States Supreme Court has used, those terms interchangeably in a variety of different contexts, and so that's not going to work either. So yes, all the key terms have now been defined in a binding way by the United States Supreme Court.
So is it fair to say the way to think about it is that, if I were a judge, I would read the language, the right of the people to keep and bear arms. I would read that. And then I would say, well, how has the Supreme Court defined each of these words? And then I would look at the Supreme Court's opinions really kind of as a dictionary to glean those meanings. And then I would apply those meanings to like the case in front of me, whether or not be gun bans, a gun ban in a sensitive place case or whatever. That's kind of how I would start the process.
100%. That's exactly right, Mark.
And then once I see a modern day gun control law that is implicated by the text as defined by the U.S. Supreme Court, then at that point, it seems like what happens is the burden shifts to the government to show a long-standing tradition in this country, going back to the founding, that we always regulated or restricted that particular gun control law. In other words, the modern day gun control law has its seeds, if you will, at the time of our founding, such as you can't misuse firearms to commit crimes. Is that kind of how it works at that second step?
That's right. And you put your finger on the key issue. It has to go back to the time of the founding, 1791. Laws from the middle of the 19th century, let alone later, simply are irrelevant to this question, unless they are a confirming analytic. So it is true that in Heller and Bruen, they looked at some laws that were after, let's say, the 1820s, but they did so to say, well, look, this confirms the original meaning. But those later laws can never undermine the text, and they can't undermine the original historical understanding in 1791. If they do, then they're rejected as irrelevant.
So let's just talk a little bit about how history plays here. The way I see it, David, is that the plain text really articulates the full scope of the right, and then the government bears the burden to try to narrow that or say, this particular instance of regulating or restricting gun rights, this goes back to the time of our founding, and therefore it's allowed. And if they can't find a historical analog, what happens?
They lose.
So there's been a lot of discussion of this, and I've written on this. Explain to the viewers, why is 1791, meaning the time period of our founding, why is that the relevant time period for interpreting the meaning of the Second Amendment and the understanding of the founders about it? And why is that so important to modern day judges?
Yeah, let me give you a little bit of background on this. So there's this debate of, is it 1791 when the Second Amendment was adopted, or is it 1868 when the Second Amendment became applicable to the states? It's important to understand that under United States Supreme Court precedent, it was generally understood that the Second Amendment did not apply to the states until the 14th Amendment was ratified in 1868. And so what that means is if one of the original states wanted to ban guns, it wouldn't violate federal law. Now, there were state law prohibitions on many of those activities, but it wasn't a matter of federal law. And then in 1868, there's what's called incorporation, where the Bill of Rights is deemed to be adopted and applied to the states. Now, by the way, the United States Supreme Court rejected that argument in the 1870s with respect to the Second Amendment and said, no, it wasn't incorporated. It doesn't apply to the states. And it wasn't until 1895 that the first part of the Bill of Rights, the Takings Clause, was deemed to be incorporated. And then it wasn't until 2010 in McDonald that the Second Amendment was actually deemed to be incorporated against the states. So you've got this dispute, but the bottom line is it's crystal clear that the right answer is 1791. And that's true for a couple of reasons. Number one, the United States Supreme Court has said there are not two versions of the Bill of Rights. One that applies to the federal government in 1791, and a second that applies to the states in 1868. And that's true for the First Amendment and all the other amendments, including the Second Amendment. So there aren't two versions. And then the other thing to know is the United States Supreme Court has consistently held that 1791 is the date by which you determine the meaning for all the other provisions of the Bill of Rights. And of course, That's what they did in Heller and Bruen as well. So it's true in Bruen, they noted there's an academic debate and that there's some, crazy academics who are hypothesizing that the meaning of the Second Amendment changed and that it was readopted vis-a-vis both the federal government and the state government. This binding Supreme Court precedent forecloses that analysis. It's ridiculous, and that's not going to work. Now, the anti-gunners want this because at the time of the founding, for many of the things they're trying to effectuate now, like magazine bans on AR-15s, age restrictions, the full panoply of modern day gun control, there's nothing at the time of the founding. They're going to lose. It all falls within the plain text, and they don't have any historical analog, and so they know that. So they are desperate to shift the conversation to 1868, which candidly isn't really much better for them. But if they can get to 1868, and then they can say, oh, and let's look a few decades later, then there's at least a smattering of gun control laws that in the 1880s and the 1890s, it's still candidly not enough to justify any of what they're trying to do today. But that's why they're trying to make this maneuver. At least they have something to talk about if they keep their focus where it should be on 1791 and the period immediately thereafter. They're going to lose pretty much on every issue with a few minor exceptions.
Yeah, I think that's a great point, David, that there were more sort of gun-related laws after the Civil War, probably in large part because we had just fought a civil war and there was, among other things, there was sort of military occupations in parts of the South. There was all sorts of mischief going on, post-Civil War as the country was trying to bring itself back together. And in the context of that, you did see efforts to sort of disarm potential future uprisings and things along those lines. So I could see why there would be some additional gun control laws in that period. And again, if I were the anti-gunners, by looking at that late period, you can try to say, well, there's gun laws at the time of the founding plus anything after the Civil War. But it seems to me the Supreme Court hasn't really bought into that because, for example, in Bruen, it seems to me, David, they rejected a lot of those quote unquote Wild West territorial laws as outliers and not teach us in anything. And those were right smack dab in that late 19th century period.
Absolutely, Mark. And in 1871, Texas had a ban on carriage. And the Supreme Court said, doesn't matter. It's too late. It's an outlier. In 1791, there were no such bans. Certainly, they weren't widespread. There were none, but they weren't widespread in any event. And so they upheld the right to carry.
So, David, when we think about, historical analogs, this is probably not a phrase a lot of our viewers out there use in their day-to-day life. So what exactly is a historical analog? And when it comes to our Second Amendment rights, what makes up a kind of persuasive historical analog? And what are examples of historical analogs that are really not analogs at all? They don't teach us anything about the right to keep and bear arms.
Okay, so this is one of the places where the United States Supreme Court in Bruen did elaborate on Heller. And it said, look, when you're finding an historical analog, it's true. It doesn't have to be an identical twin of the modern day law, but it needs to be relevant both in terms of why it was adopted and how it was implemented. One of the things the anti-gunners liked to point to as a justification for banning carriage, throughout the United States was surety laws. The first such law was in Massachusetts in 1836. And what it said was, if someone in the community pointed to an individual as a threat and a menace to society, and if a judge, after a proceeding, agreed and made an individualized finding that that person was a menace to society, they could still carry, but only if they posted a bond, a monetary sum of money, so that if they misused their gun, then they forfeited that sum of money. It was meant to be a deterrent. Okay, so let's look at that as applied to the issue that was in Bruen as to whether there's a right to carry. Well, it's not a relevant historical analog for a multiplicity of reasons. Number one, it was an outlier. It was in 1836. It was the only state that had that. Number two, it's too late. In 1836, every single one of the founding fathers was dead. So we can't possibly understand the public meaning in 1836 of what happened in 1791. That's just too late in time. In addition, if we look at the how and the why, what they were doing is it was an individualized finding of dangerousness made by a judge, not a sweeping declaration that the entire public was too dangerous. And even then, it wasn't a prohibition. So if we look at why, it was because there was a judge who made a finding that was individualized of dangerousness. And if we look at the how, it wasn't even a ban. It was just you have to post some money. So that would be a way that the proper historical reasoning should be applied to these analogies.
Yeah, it's important, and we've talked about on this channel the notion of surety laws, because it really is a big argument that you see come up all the time by sort of the briefs submitted by government defendants, where they're trying to say, look, we have these gun restrictions, these surety laws, but you're right, it starts off in Massachusetts, way after the founding era, and for all the reasons you've articulated, that really doesn't teach us anything about, these sweeping gun laws that we now see in America today. So I think that's an excellent point.
And let me just say, Mark, one other thing on that surety law. If you just step back for your viewers, the anti-gunners in Bruin were saying that in Massachusetts, there was a total ban on carriage. And then they said, but it was relaxed with the surety law. If that were right, then in 1836 in Massachusetts, the only people who would be able to carry were the people who were deemed so dangerous by a judge that they had to post a bond, and nobody else was able to carry. And so that's another way, you have to look at the anti-gunners arguments in context and put all the laws together and see if they make sense. And under their rendering of history, it was just obviously nonsensical that the only people that could carry were people who were found by a judge to be a menace to society and had to post a bond.
David, I think that's a powerful point you've just made, and I just want to touch fingers with that for one additional second, because one of the things we do on this channel is we sometimes get into these kind of geeky details, but you're absolutely right. In NYSRPA versus Bruin, as I recall, the anti-gun briefs were really saying that this thing called the Statute of Northampton, which literally was adopted, I think, in the 1300s in England, before I think the birth of William Shakespeare, among others. And the Statute of Northampton, they argue, came to Massachusetts and banned the carrying of firearms. And then these surety laws come out. So tell us a little bit about the Statute of Northampton and the interplay with these surety laws, because I think that is really telling about how the anti-gunners try to make these legal arguments in court.
Right. So the Statute of Northampton, Mark, as you said, was passed in 1328. So basically 300 years before Shakespeare. And of course, we did fight, a war to be freed from many of the aspects of English law that we didn't like. But it is true that there were a few historical analogs to the Statute of Northampton that were adopted in places like Virginia and Massachusetts. And the reality is that those bans were just on riding to terrify people. If you were a group, a lawless posse, drunk at night, or riding around with your guns, that was going to be a problem under the Statute of Northampton. But one of the things that the anti-gunners failed to do in Bruin was to identify a single U.S. citizen who had ever been arrested for peaceably carrying a firearm. They had no one in the entire colonial period, and that's the dog that didn't bark. And so it was obvious that that wasn't what those statutes meant, but they had to erect a cathedral around it because they had nothing else.
So, David, we've just talked a lot about part two, right? You start with the plain text as interpreted by the Supreme Court. Then, once the law is implicated, modern-day gun control law is implicated, it shifts the burden to the government to talk about historical analogs. We've just talked a lot about historical analogs. I want to step back for just 1 second and talk a little bit about the plain text, because there's an issue that seems to keep coming up as I've been reading various briefs across the country as part of what I do here as a reporter. And what I've noticed is that there's an effort by a lot of the government defendants to justify their modern-day gun control laws to try to bring the fight to the plain text, to say things like ammunition is not within the plain text of the Second Amendment. Magazines are not expressly mentioned in the plain text of the Second Amendment. The right to make your own gun is not specifically mentioned in the text of the Second Amendment, and therefore these laws restricting these activities or banning these activities don't touch fingers with, are not implicated by the plain text of the Second Amendment. Therefore, so the argument goes, is the government never has to come forward and meet a burden to show that these modern-day gun control laws are constitutional under the Second Amendment, because these gun control laws never actually implicate the plain text. So you never have to go to step two of having the government meet its burden to show that they're constitutional with historical analogs or whatever that happens to be. So how does all that work, David? What's your take on that plain text argument that it's not mentioned in the Second Amendment, therefore it's not covered by the text of the Second Amendment?
It's totally fallacious, Mark. You can look at the First Amendment and it says Congress shall pass no law abridging the freedom of speech. It doesn't mention ink or pens or paper or books, let alone the internet. And yet everybody understands that all of those things are encompassed by the First Amendment right to free speech because they are a necessary implication of that right. So too with the Second Amendment, if the anti-gunners were to ban triggers, it's true they're not explicitly mentioned, but those are part of an arm. And there's certainly certain rights that are necessarily implied by the existence of the Second Amendment. One of them would be the right to acquire a firearm. Obviously, it doesn't say that explicitly in the Second Amendment, but the right wouldn't be worth the paper it was written on if you could never acquire one. Likewise, there has to be a right to manufacture firearms. If they banned the manufacture of firearms, then that too would be a violating necessary implication of the Second Amendment. So yes, you're right. They're desperate to make this maneuver because they know if they get into history world, they're going to lose because they have no historical analogs. So they're trying to manipulate the textual argument in ways that are intellectually dishonest and that are foreclosed by binding precedent from the Supreme Court.
So let's just take an example of the right to acquire. And we have a case, I think it was called the Rigby case out of Wilmington, Delaware. A federal court in the District of Delaware actually came out and said that under the Second Amendment, we have a right to make our own firearms because, again, you're not born with a gun in your hand. You have to at some point acquire a gun. So how does that sort of logical process work in a case where, someone is saying, hey, you have no right to make a gun or acquire a gun because it doesn't mention it in the plain text of the Second Amendment?
Right. So here again, we start with the text, and this is one of those rights that is necessarily implied by the text. There must be a right to manufacture firearms. It simply cannot be that the government could have a flat ban on manufacture of firearms. So once we understand that, then the burden shifts to the other side to come up with a historical analog. I'm not aware of any historical ban at the time of the founding on manufacture of firearms. So I don't think they can win that. But that's the right way to think about it.
Yeah, and also when we talk about magazines, this is another interesting one, David. It seems to me as I read the Heller decision from 2008, and then I read the Supreme Court decision at Caetano in 2016, the per curiam, they make it very clear that we as Americans under the Second Amendment are entitled to keep and bear modern firearms, which by definition are semi-automatic firearms. So how does that play out in the magazine debate where, last I checked, I don't think I have a semi-automatic firearm that doesn't take a magazine, at least last I looked. But how does all that work?
Okay, so 2 points there, Mark. Number one, the anti-gunners did in Heller try to argue, well, it's totally different now because these guns are much more dangerous than they were at the time of the founding. And Justice Scalia, for a majority of the court, said that it, quote, borders on the frivolous, close quote, to suggest that only firearms that were in existence in 1791 would be covered. And one of the reasons Justice Scalia was right about that is because if you look from the invention of the first firearm to the present, it's a story of constant innovation. You constantly want to innovate so that you're not at a tactical disadvantage as compared to criminals, as compared to others who would do you harm. And the founders were very aware of that. This was happening before their eyes. I think it was in 1775 in the Continental Congress. Someone came in and showed them a gun that could shoot 20 bullets without reloading. And this was a technological innovation at that time for the Continental. So they saw this, they were aware of it, and Justice Scalia was absolutely right to say that. So that's the first point. The second point is when we're looking at bans on arms, and certainly magazines would count as an arm because they're an integral part of the functioning of the firearm. And if you want to have a firearm that you can shoot more than 10 times without reloading, you must have a magazine. The test is it commonly used by law-abiding citizens for lawful purposes? Now, when we're talking about magazines, my understanding is there's something like up to 576 million magazines with more than 10 bullets in the United States. So under any definition, 500 million magazines would count as common use.
David, let's talk about that. Now, this is something I've really stressed hard on my channel to try to educate my viewers. Heller actually created the test as I see it, and I want you to correct me if I'm wrong here. The Heller decision created the test. They looked at the text of the Second Amendment. They looked at the history of the Second Amendment. They looked at any historical analogs involving the Second Amendment and asked themselves is what in American history allows government to ban arms, in any respect, to ban arms, not regulate, to ban arms. And they came up with the in common use test. And tell us a little bit about, am I right here? Is this Heller in common use test still the law of the land? And what's in it and what's outside of it is still the law of the land?
Yes, it is the law of the land. Is it commonly used by law-abiding citizens for lawful purposes? And use for purposes of the Second Amendment includes owning. And that makes sense because if you own a firearm, it has a significant deterrent effect on those who would do you harm, number one. And number two, owning the firearm is a precondition to using it by brandishing it or having to shoot it to ward off an intruder or for any of the other purposes of the Second Amendment. And so that is the possession is a subset of use. And so we can look at the statistics and the survey data and the industry data to look and see, well, is it commonly possessed, commonly used? And the answer with respect to magazines is yes. And that's the same is true for AR-15.
Noticed in some of the government briefs, sort of the anti-gun briefs that I've seen out there, they're trying to modify the in common use test. And it's very creative. And frankly, if I were hired by the anti-gun community, if I was hired by one of these governments to justify their modern day gun control law, I might even try to make the same argument too, because as you know, well, your job is to win for your client and make the best argument you can. So I don't blame the lawyers at all for doing the best they can. It's their job. In fact, they have a duty to do the best they can for their clients. But what I'm noticing is the way the lawyers are arguing this is they're trying to say that the legal standard is in common use or commonly used for self-defense only, and that the burden on the pro-Second Amendment plaintiffs is to demonstrate that people commonly use these guns, meaning they shoot 30 plus rounds to defend themselves. And this is a common occurrence that in common use for self-defense is commonly all over the country at all times. People pull the trigger all the time. That seems to be where they're trying to redefine the standard, but that seems entirely inconsistent with the language of Heller. And I think even Justice John Paul Stevens in a dissent in Heller talked about this is for all lawful purposes as he interpreted the majority opinion. So how does that interplay work between in common use for lawful purposes versus in common use for self-defense, which is where I think the anti-gun community would like the standard to go?
Yeah, that's just an add-on, Mark. I mean, I understand, as you say, as advocates, why they're making that maneuver, but it's inappropriate because that's not what Bruen said. That's not what Heller said. They didn't add for self-defense. And candidly, even if they had said that, we would still win because possessing it is using it for self-defense. 90 to 95% of the time, a gun owner simply has to brandish a firearm, and that ends the result. Most criminals don't want to find out how many bullets are in, and they run off. And so obviously it has a bigger deterrent effect. The more magazines the more bullets in the magazine, but particularly for the people who are subject to multiple attacks. So the argument just doesn't work.
So when it comes to in common use, David, who has the burden of proof? Do the pro-Second Amendment people have the burden of proof to show something's in common use? Or is it really the government that has to come forth and say, these semi-automatic rifles are not in common use, or these magazines are not in common use? How does that burden shift, when we're talking about the in common use test for arms ban or arms possession ban cases?
Well, here again, we look at the plain text. And is this an arm? Yes, it is. Now the burden shifts to the government. Regardless of who has the burden, we would win. I mean, I would point to, number one, the survey evidence. So Professor William English of Georgetown did a very comprehensive survey. He found that there were up to 576 million magazines in the United States with more than 10 bullets. And one of the things I like about that survey, Mark, is that you're always worried about, is this truly a reflective sample of the American people? So Professor English asked people, how many bicycles do you have? And then he extrapolated that to the total population of the United States. And we have very good data on how many bicycles there are in the United States. And his numbers matched up precisely to those overall numbers. So it's a nice check There are a multiplicity of reasons why to think that this very large random sample was fairly reflective, but it was. And so there are hundreds of millions, over 500 million of these in the United States. In addition, we can look to industry data because industry knows how many they're manufacturing, how many they're selling, and that is also consonant with the fact that there are hundreds of millions of these magazines in the United States right now.
David, there's one thing that's always confused me a little bit about this issue, and that's this. If you go back to Heller, there was no trial in Heller. There was no evidentiary hearing in Heller on the number of handguns in America. Nothing at all like that. And yet the United States Supreme Court in Heller was able to just say, like as a no-brainer, which of course is true, they were able to say, obviously, handguns in America are the preferred weapon of self-defense, and everyone has a handgun in America, so we don't need to have a trial. We don't need to worry about this. We just know that handguns in America are in common use and cannot be banned. So it seems to me when I read a lot of these briefs out there, David, in these litigations involving like magazine bans or so-called assault weapon bans, which are just bans on semi-automatic rifles, it seems like there's a lot of back and forth about, well, how do we know this? How do we prove this? But it's almost like, well, if the Supreme Court didn't need a trial, they didn't need a hearing, they didn't need a bunch of evidence on that handguns are ubiquitous and in common use by Americans. Why do some of these courts and some of these arguments occur that we need trials and all this evidence on stuff that's kind of self-evident in American life?
Well, really, there hasn't been that much contestation on the question of whether these are commonly possessed. The anti-gunners are instead fighting at the level of, well, what is the test? Does it have to be used for self-defense? We've talked about why that's wrong. And there were trials, and I did one of these trials on a magazine ban for New Jersey back in the pre-Bruen days, where there was interest balancing and the judges were trying to figure out, well, what would be the statistical consequences of banning these versus not for mass shootings and for other purposes. And now that's just not relevant anymore. So the other side's trying to create a triable issue with these saying we need historical experts. And we know that's not right because in Heller and Bruen, there was significant contestation over the history, and there was no experts whatsoever. And both sides presented their evidence. The amicus briefs came in, presented their historical evidence, and judges do what they always do, whether it's reading old cases or reading old primary documents, like the Constitution itself. They don't need experts to come in and tell them how to read the Constitution.
Yeah, David, that leads to the next question I had is we have seen in some courts discussions about we need historians to come in and teach us as judges how to interpret the Bill of Rights, specifically the Second Amendment. And that's kind of perplexing to me because I always thought that the role of a judge is to interpret the law and to figure it out. In other words, when it comes to figuring out what American law is, especially the Constitution, it is the role and the province of the judges to make these decisions. So why are we seeing some judges and some discussions in these courts that judges need help from historians to come in and teach them what is the meaning of the Second Amendment? I don't think we would do that with other aspects of the Bill of Rights and have someone come in and teach us what the First Amendment means. I can't see a judge do it in any other context. So why is there some discussion about using historians as expert witnesses to teach judges the meaning of the Second Amendment? What's going on with that?
Well, Mark, you're right 100%. This isn't something that's done in any other part of the Constitution. When we look at the original understanding of the First Amendment, we don't reach out and find experts, and courts don't appoint historians to help them, figure out what it meant when it said Congress shall pass no law abridging the freedom of speech. And we also don't need an historian to interpret the right of the people to keep and bear arms shall not be infringed. The parties are more than capable. I really don't know what's driving this, but certainly I think some of these judges are desperate because they read these government briefs and they see there are no historical analogs, and they know they're going to have to uphold the law as a result of that. And so I don't know if that's what it is of trying to get some help to find something that's just not there. But spoiler alert, you can bring in these experts or not. The reality is there were no laws that justify the vast majority of modern day gun control.
The founding period of the United States is over 200 years ago, right? For the last 200 years, I mean, you were at Harvard undergraduate, you were at Harvard Law School, people at Harvard and the rest of the Ivy Leagues have been studying the founding fathers' intent. They've been reading the Federalist Papers. They've been writing books about the Anti-Federalist Papers for 200 plus years. So it seems to me that the history of the founding generation as to what the founders' intent involving the Bill of Rights was, well, let's just say it's pretty well plowed ground at this point. So what more needs to be done in this area? Because a lot of these judges are like, oh, well, we need to, I'm not saying the judges are doing, there seems to be discussion at least in some of these courts. I'm not saying the judges are agreeing with this. A lot of the judges are not agreeing with more discovery or anything like that. But there seems to be some argument saying we need more time to do research on the Second Amendment. That seems a little incredulous to me since we've been studying the Constitution for over 200 years.
Well, Mark, you're right about that 100%. But let me make another point, which is these states, shame on them, because they're supposed to honor constitutional rights. And they should not even be passing these laws unless they have first done the historical work to justify their passage, and for them to come into court and say, well, Your Honor, we need more time because we're still looking for something. That's got it totally backwards, and it's totally antithetical to the idea of honoring constitutional rights. They never should have passed these from the beginning unless and until they could find relevant historical analogs, which of course they couldn't, because so much of this is virtue signaling from the anti-gunners.
Well, David, that's actually a very powerful point that I guess I hadn't fully appreciated. You're absolutely right that when state or federal legislators, when they enact laws, they have sworn an oath. They put their hand on a Bible or something analogous to that, and they swore an oath to uphold, among other things, the United States Constitution and state constitutions. So when they vote for laws, the gun control laws, they're basically vouching for the fact that they did the research they need to do to confirm this is consistent with the Constitution and doesn't violate it. So you're really saying that when they enacted these laws, they've already vouched for it. It says, we did the research, we looked at the history, we've analyzed the Constitution, and we've concluded it's perfectly fine. So when they get sued over it, the work should already have been done, and they don't get more time after the fact, post hoc, try to make something up and invent something that they hadn't already considered. Because you're right, they should have done the work ahead of time.
Exactly right. Exactly right.
Great. Well, David, I really appreciate your time here. I know you're extremely busy. I mean, we read about all your work in the papers and everywhere else. And I just want to ask one final kind of question here, and then add anything you'd like to. But there is this sort of language we see in Bruin about new societal problems different at the time of the founding, or new technology and whatnot. It seems to me they're just looking down the chessboard. If something unusual pops up down the road, we can reconsider all this. But in terms of the Second Amendment right now, I don't know what exactly they'd be talking about that's like a new social problem other than human violence with firearms and all sorts of weapons and protecting innocent lives. Doesn't seem like that's a new societal problem today versus the founding era. But any thoughts on this discussion we're seeing in some of the sort of anti-gun briefs that maybe some of these issues with modern firearms are somehow implicating new social problems that the founding fathers never anticipated?
Mark, I don't think I can improve on the book of Ecclesiastes, which says in chapter 1, there is nothing new under the sun. There's nothing new under the sun. From Cain and Abel to the present, we've had murder, for example. Indeed, at the time of the founding, the murder rates in New York and Boston and Philadelphia were 10x what they were in New York City under Bill de Blasio. That tells you how much murder there was at the time of the founding. And so these issues, the need for self-defense, they have been compelling from the founding to the present. And I don't think this is going to be an argument that the anti-gunners are going to get a lot of mileage out of. And even if they do, we're able to find some new phenomenon that isn't a get-out-of-jail-free card. They still need to point to historical analogy. It's true they might have a little bit more flexibility if it's truly a new problem. But in fact, these pre-existing problems cut our way, because one of the things Justice Thomas said is, and if it's a pre-existing problem that was at the founding and they didn't regulate it in the same way that the anti-gunners want to regulate it today, then that cuts our way as a basis for concluding that the modern day regulation is improper. So I would just say to you, Thanks for everything you're doing. Your channel's awesome. It's super informative. I learn from it every day, and just keep up the great work.
Great. Well, David Thompson, thank you very much, of the law firm Cooper and Kirk. We're all cheering for all your excellent work out there for the Second Amendment. And, we look forward to seeing you maybe before the United States Supreme Court in the near future on a case involving the Second Amendment's right to keep and bear arms.
Thank you, Mark.
Great. All right. Thanks, David. We'll talk to you again soon.
Orders up. Table 2A.